Are there any further witnesses?
No, sir.
I have none.
Is all the evidence in?
We would like to call your attention to this previous award in which Arbitrator Marshall held that this same hospital could not discipline an employee for smoking in a posted no-smoking area. Now, in this case, we established that the rule had never been enforced and had been ignored even by management. The arbitrator chastised the hospital for not properly putting its employees on notice. Now, this case suffers from the same fault.
We are aware of the award cited by Mr. Murphy, but it is not controlling in this case, since it involved an attempt to enforce an order of the fire department, not clear-cut contractual language which both parties have agreed to abide by. I submit to you a recently published arbitration award which held that employees were responsible for knowing what was in their contract and for knowing their obligations as employees. This case is specifically in relation to a contractual requirement to call the employer and report absences on a timely basis.
Well, gentlemen, are you now ready to present your closing statements?
Yes, sir.
Yes, sir.
Well, it is my practice that the party which made the opening statement last to be the first to go forward with the closing argument. And therefore, if there is no objection, I'll ask you, Mr. Murphy, on behalf of the union, to make your closing statement.
Mr. Arbitrator, it is clear that the city has failed to meet its burden of proof obligation. It is clear that the hospital management was in such haste to respond to pressure from the mayor that it failed to consider the rights of its employees under the contract, much less to consider their rights as human beings. It was in such haste that its ill-conceived notice to the employees was so inaccurate and so incomplete that it was misleading as to its scope and intent. It was in such haste that it did not even allow the grievant an adequate opportunity to explain his actions. Now, we have proved that Mr. Novak is an outstanding employee who has several times been commended for his job performance. We have proved through expert medical testimony that his midday jogging has been a positive impact on his ability to continue his excellent level of performance. We have proved that the grievant has voluntarily substituted other authorized time off in exchange for a slightly longer lunch period. Management clearly gets the better of this trade because they gain a more physically fit, mentally alert employee. Now, the union is not challenging management's basic right to enforce its rules or to discipline its employees for just cause. It clearly has that right under the contract. But concomitant with that right is the responsibility to exercise that authority with justice and fairness. Now, the employer has charged that it was forced to administer this harsh discipline because the grievant repeatedly flaunted the rules in his supervisor's face. And yet we have shown that the grievant was late only 3 times prior to the day of his suspension. We have shown that the grievant was making a very sincere effort to comply. And the time in dispute had been reduced to a negligible amount by the 4th day when he was suspended. Now, this hardly qualifies as repeated flaunting, necessitating this drastic imposition of discipline by management. In view of these mitigating circumstances, we ask that you uphold the grievance.
Well, thank you, Mr. Murphy. Mr. Calloway, care to make your closing statements, sir?
Mr. Arbitrator, the issue before you is very simple. Was the 10-day suspension given to Mr. Novak for just cause? We have met our burden of proof. We have clearly proved that the answer is yes. Now, I simply refer you to the city's contract with its municipal workers, a document which both the city and union agree is a fair and effective guideline for our relationship together. That contract gives management the right to suspend for just cause. Ms. Curtis provided uncontroverted testimony that she posted an appropriate notice to the employees that work rules would be enforced, and that she met with her subordinates, including Mr. Novak, to explain the full implications of the policy change. We have proved that Ms. Curtis properly applied the principle of progressive discipline. She twice warned Mr. Novak orally of the consequences of continuing to violate policy. She issued a formal written warning, and then she issued suspension. That these disciplinary actions occurred on successive days and that the suspension was substantial was a direct result of Mr. Novak's continual, deliberate, and defiant violation of the rule, without even the pretext of an excuse. He acted as if it were his right to set his own schedule. We think this qualifies as flaunting, and that he gave Ms. Curtis no choice but to issue stern discipline. Mr. Murphy would have you believe that Ms. Curtis was somehow at fault, that she failed to make her warnings sufficiently clear, and that the violations were minor. We believe that the evidence shows that she is a good supervisor who stood up to a difficult challenge to her authority. In the interest of efficiency and morale to all employees, we cannot make special exceptions for people who set their own rules. We have hundreds of employees who willingly abide by the rules and live up to the obligations of their positions. David Novak acted as if he were an exception to those rules. But he is not. They must apply to everyone or to no one. We think the adequacy of the bulletin speaks for itself. We leave it up to the arbitrator to determine whether or not a prudent person could have so completely and so conveniently misconstrued its intent. We believe, with your reputation for fairness, we can feel confident you will uphold the action taken.
Very well. Well, thank you, gentlemen. Will you be filing briefs?
We will file a brief, sir.
Do you really think that's necessary, Tom? We've both made our positions clear to the arbitrator. I doubt that we'll need to argue any fine points of law. Post-hearing briefs would just add to our costs and delay the award. We've got a real problem on our hands here. We need to get on with it.
I'll agree to that.
Well, very well then. I will deem these hearings closed, take the matter under advisement, and will endeavor to get a decision out to the party within 2 weeks.
Thank you, Mr. Arbitrator.
Thank you.